Hello, this is Matt from CPA Academy, and I'm here to introduce you to this program. This program will be for 1 hour, but it'll seem a lot longer than an hour. This program will be about 8 steps to a good Florida estate plan, but it will not be a good program. The estate plan may be good, but the program itself, not so good. Who's watching? Oh, I see you. All right. Let's see, is everyone paying attention? There will be polling questions, but you don't need a poll to answer them. The cat from Connecticut, please call me at 888-443-7722 so that we can have a conversation. Where is that speaker? He's not back there. He's coming soon. We're going to start on time, and we're not going to end on time, and you'll wish we had ended earlier. If you have any questions, you can click on the question box, type the question in, and hope that your question will be answered. I'll be answering most of the questions today. The speaker has no earthly idea. Thank you very much for attending this webinar. If there are people who you do not like, please let them know about the webinar. Thank you. All right. Welcome to Saturday morning. I couldn't think of anywhere I would rather be other than France or maybe Italy or Jordan, but we're going to talk today about 8 steps to a successful Florida estate plan. I've got some old materials which will probably look new to you. We're going to talk for 1 hour, and then after the hour, I'm going to again try to properly explain the Estate View software, which I've been trying to do for 2 to 3 weeks in a row now, and I keep making mistakes. So we'll see if we can get it right. If you came in through CPA Academy, you will get continuing education credit. If you have any issues with the polling questions or anything like that, just send us an email, agassman@gassmanpa.com, and we'll make sure that you get your CPA credit. If you are a lawyer and you want Florida bar credit, please just make sure you know that that you attended, and we'll send you a pretty certificate, which will be one of the nicest certificates you've ever seen. If you have questions and you want us to answer them, just click on the question box there or the question pyramid and type in the question. Carolyn, do I have more than one puppet? Yes, I do, and they all talk. Okay. All right, where can we find the handout for this presentation? It's in there. Go to the handout thing and click handout, and if it doesn't work, email me and we'll make it work. Everything that we do here is situated onto our YouTube website. So if you want to see anything, if you have trouble sleeping at night, as Stace Eastland says, our presentations are guaranteed not to be habit forming, and they're all there so you can enjoy them. If you have an organization that would like to have a speaker or would like to have a presentation, please just let us know, because we have a lot of presenters. All right. Some replays are available here, as you see, and some upcoming events. Brandon is going to speak next Saturday on a refresher of the Employee Retention Act, and he'll also be showing you some of the new features on Estate View for self-canceling installment note calculations. Then Christy Nicolo, the following Saturday, is going to talk about spousal limited access trusts. I'm going to then talk the following Saturday about evaluating estate tax techniques, and I'm going to do this as a 3-part series, June 3rd, June 10th, and June 17th. Followed by June 17th at 1, we're going to talk to the #1 tuba player in the world and world history, Chuck Dallenbach, about how he got where he got. So I've got a lot of slides here I'm going to pass over, but not regardless of your favorite holiday, you can go back and look at any and all of these slides and use them as much as they want. So there are 8 steps to a successful Florida estate plan. The most important step is to start. You have to start somewhere. You have to decide I want to help someone put together a proper Florida estate plan, or I want to have a proper Florida estate plan. By the way, I saw my first last will and testament by chatbot, and it was not very good. So one idea would be to use a qualified lawyer to do your estate planning. Even qualified lawyers make a lot of mistakes because it can be very, very complicated, and I will leave it at that. But step number one, for those of you who took computer science in the 70s, when I was in college, they used to say garbage in, garbage out. It doesn't matter how good your computer is or how good your estate planner is. If we don't have the right information, then we're not going to do the right planning, especially when it comes to creditor protection planning, probate avoidance planning, and estate tax planning. So we love it when somebody comes in and has beautiful records showing all their assets, how they're titled, what their values are. And most of those people were in the US military as officers, by my experience. They do a fantastic job of keeping great track of their information. Other people have their CPA prepare or their financial advisor prepare a periodic balance sheet. That is very, very useful. And I can tell you for a lot of our very, very wealthy clients, the financial summary that we prepare can be 12 feet long and 4 feet wide, showing every entity, how it's owned, what it does, what it owns, who it owes to, how it's taxed, and what needs to be done. So that there's just no shortcut to that. And when you say to a lawyer, would you do my estate plan for $750? Well, you know, if it takes $1,000 worth of time for us to get your information sorted, that is going to cause a higher cost, but may be a higher success. So what we like to do, and this is a very simplified chart here at page 29, is to put together a summary of the client's assets, the client's liabilities, and the entities. And we like to do a before summary and an after summary. We do all of these in Excel. It's not easy to learn this, but it's worthwhile. Yes, Excel will draw squares and circles and lines and arrows. And then you could actually have all the numbers in your Excel illustration tabulated in a separate Excel spreadsheet. So when you change one number, the spreadsheet can change. But here, what we like to do on these is you show the client, and then below the client, what the client owns, and then below each entity, what the entity owns. So it goes from top to bottom. So John and Mary have a tenancy by the entirety's ownership of the Smith Family LLC. It's a Wyoming LLC. We formed it there for confidentiality purposes. The LLC has brokerage accounts. It has what they call risk-free investments. Now, they also have some S corporation stock that's owned separate from the LLC. We don't want to lose the S election. And then under the Revocable Trust of John, it says we'll own no assets until after John's death, because under Florida law and the law of most states, creditors can reach assets held in a living trust, and assets that would otherwise be protected from creditors, like life insurance and annuity contracts, become unprotected if you put them in to a Florida revocable trust. And then we have John's life insurance payable to his trust in the event of his death, and Mary will be the beneficiary of the trust, as noted here. So when these clients come back to see us 5 to 8 years from now, we'll be able to pull out the chart, look at it with them, and they'll have some memory that this is how their estate plan works. We're going to go into more detail, of course, but without a chart, without a picture, we will often not have as good of an estate plan. So a more advanced estate plan, just for illustration purposes, there's the spousal limited access trust. that the husband establishes for the spouse and descendants. Creditors can't reach into it. It owns a subsidiary trust, which then owns a separate LLC and also owns 30% of an S corporation, which owns a medical practice. Now, in Florida, you can have a medical practice entity owned by a trust if you follow a number of rules, and I can make that available to you if you like. But here is our old information gathering guide. We suggest that you as a professional have a good guide that your clients can use. If you'd like a copy of our newer version, please let us know, but it's not in our 8 Steps book yet, so that's why it's not here. But obviously there's a lot of information that people will want to know and that people will want to share with you. If clients are looking for confidentiality, they could fax this and it will not be on the internet anywhere. So the fax machine, I think, will come back into popularity as a result of all the cyber theft going on. But it's good to know who the client's advisors are, what their marital situation is, who they like, who they don't like. Did they acquire any assets while living in one of the community property states, which can be important. So it's always a good idea to know what you own. I like what one of our financial advisors that we work with does a column for every year. So he shows all the client's assets and what it's worth, what each asset is worth at the end of each year. So you can see if you're increasing or decreasing and how things are varied. And when you give your estate planner the information on the assets, tell us, if you think you know, what each spouse owns. Now, we will do a Nexus Lexis search after we get client consent. It costs between $25 and $50 a person, and it will tell us all deeds in the name of the person, all vehicles in the name of the person, all companies in the United States that the person is named on, and we usually find some things that the clients don't know or don't remember. So I'm going to get to the first polling question here. It's a very, very difficult polling question, so you may need to call someone for help. The question is, would you like to receive a free copy of our book, 8 Steps to a Proper Florida Trust and Estate Plan? Sorry. The possible answers are A, yes, B, no, C, I would rather read the dictionary, and D, the correct answer was yes. So you can pick any of those while I go and get a cough drop, and Josh will let us know when we have enough people answering. Wake up your cat and let your cat answer. Meow. By the way, that was not a real cat. For those of you who are animal rights people, I would never imitate a cat. Meow. All right. Step 2, and this is very important for young families and for clients who are not mega millionaires. Do you have enough life insurance? And for the estate planner, what we're really saying is your family going to have enough investments or enough liquidity if you die? And we're talking about the death benefit most of the time, not necessarily a permanent life insurance policy. So I look at the clients and I say, you're here for estate planning. If one of you dies, or if you both die, is there enough for the survivors? Is there enough for your beneficiaries? And the clients typically say, well, how much is enough? And I typically say, if you can live on about 4% of your investment assets a year, and you invest conventionally, which would be stocks, bonds, in appropriate allocations, mutual funds, or perhaps income producing real estate, then you can live forever based upon Monte Carlo analyses that go back to 1933. So if the breadwinner is going to die and leave 3 million of investments. 3 million times 4% is $120,000 a year. Is that enough? And if it's not enough, and if you say, well, I'd like for my spouse not to have any debt and we owe $1 million on the house, and I'd like for my spouse to be able to spend $400,000 a year. Well, then you need enough life insurance death benefit so that there's enough net worth at the end of the first spouse's lifetime to have $11 million. So you can back into that. Now, once the client says, okay, I agree with you, Alan, I'm healthy. I think I need $6 million of death benefit. I've only got 2 million. Where do I get the other 4? And the answer is you get it from the life insurance agent or agency or carrier of your choice. But please get at least 4. Because when the client sits down with the agent may say, well, I've got a better idea. 4 million of death benefits, great, but wouldn't you like to have a savings program that's creditor proof and grows income tax free and can generate a death benefit way past the age of 50? And the client needs to decide if that's worth the extra money. But some clients say, oh, well, I'll find out how much it costs and I'll use an agent who tells me how much it costs before I engage the agent. Well, that doesn't really work, because until they have your health information and they've taken your physical, they can't really give you a set price. So it may be advisable to use an agent or an agency who will shop the coverage among various carriers once the physical has been taken. And there are 2 types of life insurance applications. And one is a formal application and one is an informal application. And if I sign a formal application, when I get my physical, if there's a blip in the EKG or they find some marijuana in my blood for some unforeseen reason, that is instantly published to a bureau and it stays there for 8 years. On the other hand, if I fill out an informal app, then my blood test, my physical results, what an initial carrier decides to do is not published to the bureau. So if I have a unusual EKG blip, or I have something in my blood that normally is not there, I can say, oops, never mind. Let me go ahead and take that physical exam again. And then once my agent gets a bid from a carrier based upon the informal app, then they can make the app formal, and the bureau does get that information. And I'm a big fan of term life insurance because I want my clients to get the right death benefit. So they say, how much does it cost? I show them these charts. So if the client is a male, non-smoker, in great health, we can get a 20-year term policy, $865,000 per million, or a 30-year term policy, $1,495 per million. And I remind the client, if you get a 20-year policy, you can extend it by converting it to a permanent policy, but that's a very expensive way to do it. So if you think you're going to need a death benefit for 30 years because your children are very young and you want to get them through college and graduate school and you don't have a high savings rate, then you go 30-year term. If you're pretty sure 20 years is all you need, you might go 20-year term, but make sure you put in your calendar the convertibility deadline date for that policy, because you could buy a 20-year policy, but you can only convert it to permanent, say, up through year 17. So, and the agents typically don't tell you that convertibility deadlines are coming up. So that is a little bit about life insurance. If the client's going to get a permanent life policy, I recommend that they run the numbers on a spreadsheet and understand the rate of return and question whether they really need a death benefit for their entire lifetime, because you're paying for that from day one, which is one of the reasons that a permanent policy is more expensive than a term policy. So let's go ahead and get the second polling question out of the way. And that is, what are you? Are you a practicing CPA? That's A. B, a practicing lawyer. C, a financial advisor. D, a business owner. Or E, a confused individual. And for most of you, you're probably two of the above, but we didn't have an F here. So Josh will let me know when we have enough people answering so that we can go forward. I hope the information we're providing you today is useful. One person asked me, do I want an annual or monthly premium for the life insurance? Well, that could make a big difference to your agent. A lot of the carriers will pay the full annual premium if the customer agrees to a monthly premium payment, because the carrier knows they're more likely to get paid if it's coming out of the bank account monthly. Otherwise, it's really whatever your preference is. Okay, step 3 for a successful estate plan, and I cannot emphasize enough how important it is that the assets be titled properly and that beneficiary designations be properly coordinated. I could draft the most beautiful trust that has the most thoughtful and complicated plans be held for your family for 1,000 years under Florida law. We can now go 1,000 years, and then if you put your accounts in the name of that trust, when you die it avoids probate, and then magically the trust goes forward, takes care of your children, takes care of your grandchildren, takes care of your great-grandchildren. But wait a minute, your broker was trying to help you and had you sign a form that says that on your death, all the trust assets will go in equal shares to your children. It completely defeats the purpose of the trust. If you are a married couple and you are clients of our law firm, I said our law firm. Sorry, that was a fraudulent slip, wasn't it? Okay. If you're a married couple and you have IRAs and 401k and pension accounts, you're probably making those accounts payable to the surviving spouse, but you're making the alternate beneficiary your revocable living trust, and then we have the proper language in your trust to allow for the longest stretch possible of distributions. But then if your IRA beneficiary is your children, it's going to go outright to them, and it could be lost to a divorce. It could be lost to silly stuff that people do. It could be lost to creditor claims. It would be subject to estate tax in the child's estate. So I can't emphasize enough that when a client dies and we go back and we have this letter we sent the client, this letter we sent the stockbroker, this letter we sent the insurance advisor, and then we get emails back, yes, it's been done, and then the client dies and it wasn't quite exactly that way. So please be careful. Please make sure that you're using a qualified advisor or advisors who know how all of this work. By the way, the artwork we're showing here on these slides comes from a website that is specifically allows you to use artwork on the web. If you get your artwork from somewhere else, it could be a very unhappy situation as to violation of copyright. Now, for Floridians, I would be remiss if I did not mention the law of tenancy by the entireties. When Florida became a state, it adopted the English common law effective July 4th, 1776, so that it would have equivalent law to the original colonies and everyone else who has adopted the common law of England. So the common law of England in 1776 did not allow women to own assets. They could not have anything in their name, but it allowed joint ownership so that a man could give a dowry or a gift to his daughter and her husband, and it would be joint as tenants by the entireties. So it would take both spouses to be able to assign the ownership, and a creditor of one spouse could not touch it. And Florida, Wyoming, and Delaware are some of the very few states who still have the classical tenancy by the entireties. So it's very important when Marcia and I open a bank account or a brokerage account in our personal names that we check the box for tenancy by the entireties. We don't check the box for right of survivorship, because if there is a tenancy by the entireties box and a survivorship box, and you check the survivorship box, then it is not protected from creditors. So many of our clients have these two revocable trusts, which are the mainstay of their estate plan, but much of their wealth is owned as tenants by the entireties for creditor protection purposes. And then they can put a pay on death document with their tenancy by the entireties account to cause those assets to pass to a revocable trust on the second death. And you can also do that with the operating agreement and by a conditional assignment of an LLC. So I met with a client Thursday, and sadly enough, he lost his spouse. They had their assets as tenants by the entireties. By the way, he lost her, she died. They didn't like go hiking and he lost her. He could have put a little tile on her and found her with his phone, but that's not what happened. She passed away, unfortunately. So I said, you have two choices. One choice is that you own all these joint assets. The second choice is you can disclaim, also known as renounce, the right to inherit her half. And as a result of that, it passes to her probate estate. And then it passes from her probate estate under her pour over will into her trust and can be held for the husband's health, education, maintenance, and support for his lifetime. So that was a good outcome as far as getting at least half of those joint assets protected from estate tax when he dies, from creditors, and if he remarries. Now, if I had known that his wife was going to die sometime soon, I would have advised him to put more of the assets under her revocable trust. And then on her death, you would have had a new income tax basis at fair market value for the assets in her trust, usually, and protection from creditors, protection from estate tax, because her trust is held for his health, education, maintenance, and support. But those are all considerations that have to be thought about when we design, implement, and update an estate plan. So more information is in the book. I hope you'll read it, especially if you have problems with sleeping. Step 4, near and dear to the heart of many clients who come to see us because of our reputed expertise in this area, is how do I make sure that a creditor calamity will not cause me to lose a significant amount of assets? And oh my gosh, if you come to the right state for this, Florida is the #1 creditor protection jurisdiction in the world when you look at the categories of assets that a Floridian can own that cannot be seized by most creditors. Now, These rules don't apply for the IRS or the Department of Justice or the SEC or the FTC or in a divorce. Those are different rules. But as far as if you're in a car accident or you can't pay your debts or you signed a promissory note and everything went wrong, what a creditor can't touch is on the left here. Your homestead up to half an acre within city limits, up to 160 acres outside city limits, IRAs, 401ks, pension plans, tenancy by the entirety's assets unless the creditor has a judgment against both spouses, 529 college savings plans, annuity contracts, permanent life insurance, wage accounts. If I'm the head of my household, I'm supporting one other person or more, then I have a salary of $5 million a year. Don't tell my partners this, but $5 million a year. I can put that in a wage account. I owe somebody $1 billion. They can't touch it. I take those wages, I move them into a variable annuity contract, I move them into my homestead, I move them into 529 plans, then the creditors can't touch them. So that's why it's important when you represent a physician or other person who's being sued to characterize their income as wages, assuming you can, as opposed to dividends, which we can talk about later. Then there's assets that are difficult for a creditor to obtain. I'm not going to go through all of this because the theme of today's presentation is to give you a good checklist and some decent knowledge. But by definition, a fraudulent transfer, that is a transfer made for the purpose of avoiding a creditor. And within 4 years of making a fraudulent transfer, it may be set aside by the creditor. There are exceptions to that, and then there's exceptions to the exceptions. But what's important is to get your creditor protection planning done before anything happens. And of course, clients say, well, I have $1 million umbrella. This could never happen. Lawsuits don't go over $1 million, do they? Well, here's a 13-year-old bicycle hit by a bus, 32 million. Here's an allergic reaction to a pretzel, 29 million. Here is one person killed by an overload truck, 730 million. Here are teachers who got sick from fluorescent light poisoning, 185 million. Here's a garbage truck death, 38 million. Here's someone who had to get a tetanus shot in an emergency room, 4.6 million. After Target refused to settle for 12 million the morning of the trial. Here's a bus shelter collapse, 148 million. Here's a dresser drawer problem, 46 million. Here's a pizza that cost 10.8 million. And remember, it was not raining when Noah built the ark. He knew it was going to rain, but he built the ark before it was going to rain. So the creditors were not able to take his giraffes, his elephant, his lions, or his panda bears. Now, how he got the dolphins onto the ark, I don't know. They kind of forgot about that part of the story. Page 83, a typical creditor protection array for a single person. Now, if this single person could find someone more wealthy than her or him, marry them, and then put equal assets into tenancy by the entireties, that would be preferable to a lot of the things we have here. But we do have the ability to set up a Nevada creditor protection trust, which could own S corporation stock, an offshore asset protection trust, and to have splintered ownership of LLCs, because if I only own 97% of an LLC, a creditor can't reach into the LLC because of the Florida charging order rules. So all sorts of neat stuff there. If you're going to use LLCs, do we have anything? No. If we're going to use LLCs, then please make sure that a lawyer reviews the LLC to make sure that it doesn't muck up tenancy by the entireties or the S election or charging order protection or cause a dispute between multiple owners. And then we have a lot of Canadians who invest in Florida LLCs, but under Canada law, a Florida LLC is taxed as if it was a C corporation to the Canadian. So that is part of the book. We have a lot of information on creditor protection because I hate to edit things out. I'm never sure what somebody may need and may not need. All right, bringing us to the third of 3 polling questions. This is one of the best 4 polling questions that we have for you today. Which book would you like to receive a free PDF of? Number A, 8 Steps, which you're already getting, but if you want 2 PDFs, you can have them. B, A Practical Guide to Kickback and Self-Referral Laws. C, Creditor Protection for Florida Physicians. Or D, What Estate Planners and Others Need to Know About Bankruptcy. So, soon as we have enough answers on this, we'll go to the next slide, which is inheritance planning. So, but first, let me level with you about something. You may not have heard this before, but if you have a level and I have a level, then we can level together, and I have leveled with you. See that? It's really useful to level with somebody. You go into the conference room and you go, Harry, can I level with you, please? And Harry looks at you and goes, yeah, you can level with me. And then you give Harry a level and you have a level and you check out the table. Okay. It's an icebreaker. The next thing we want to talk about for Floridians, and for no matter where you live and no matter who you are, even if you're a puppet or an other inanimate object, you want to plan for your inheritance, and you don't want to inherit directly. Now, one thing I could say about Florida is we are full of trust and estate litigation. As we sit here today, I am sure that there are at least 1,000 lawyers in Florida on Saturday at 11:37 a.m. working on trust and probate litigation cases because there are so many of them out there. And why is that? Because there are so many elderly people, their memories aren't so good, their willpower isn't so good, and their estate planning documents sometimes aren't so good. And you have people coming down to take advantage of them. So it's a really good idea to button up that estate plan. And oftentimes when we have an elderly client, we make it difficult or impossible for them to amend their estate plan or to transfer their assets without consent of some trustworthy people or a go-ahead from a neurologist or a psychiatrist indicating that they have all their marbles. Because what we see in Florida is 2 things. Number one, if you want to be a millionaire, move to Florida and become a housekeeper and house cleaner for elderly people in a neighborhood or condominium for over 55 and be really good at it and concentrate on elderly people who are single, and especially elderly people who are single and don't have children or don't like them. And then they may put you in their will and then die shortly thereafter. And I ran into a companion, a professional companion, who was taking advantage of one of my clients, in my opinion. And I checked her out and found that she had inherited from 3 different gentleman in the 6 years before she came to my client, where she became their caretaker. They put her in their will, and then they died. You have to wonder if they died on time or a little early. But the other thing is, don't inherit directly. And if you have an elderly person in your family, you may be able to use their death to trigger a new fair market value income tax basis. So let's say that I have a wealthy father-in-law and he would leave Marcia $1 million. Well, I would prefer that that go to Marcia as trustee of a trust. She can get what she needs for health, education, maintenance, and support. And on her death, she can direct where the assets go. It may be limited to our descendants, and it's not subject to federal estate tax on her death. Alternatively, I could set up an irrevocable trust for Marcia and our children. I could put appreciated assets into it, and I could give her father the right to receive distributions in the discretion of the trustee, and the right to direct trust assets to creditors of his estate, but only with the consent of our next door neighbor. And then when her father dies, those assets would receive a new income tax basis equal to fair market value. In addition, many Florida couples haven't thought through the following. When spouse one dies, spouse two gets the assets. When spouse two remarries, spouse three gets the assets. The children of spouse one and spouse two get to help take care of spouse three if they're getting along with spouse three after spouse three got all the assets and gave them to her children or his children. So offer your clients a marital asset preservation agreement, which says when one of us dies, the survivor will fund X% of our joint assets into trusts to be held only for the survivor and our common descendants. That will protect the surviving spouse from the housekeeper I spoke of, or the next spouse, etc. It will protect the inheritance of the children, and it will give the lawyer something to do. The other nice thing about this is that if spouse one dies, spouse two is a neurosurgeon. He's got all these assets now, but he's required by contract to put them into a Nevada or offshore creditor protection trust. That's a business reason to do that. He's not doing it for the primary purpose of avoiding a creditor. He's doing it to comply with an agreement that was signed years before. So Floridians and all people, non-Floridians alike, should be thinking about that. And I know we have a lot of sophisticated people here, but if you are interested in a trust that either your parents would put into their documents or that you would form and have your parents' documents pour into, we do have the information here. And also on these, what I would call underutilized basis planning strategies, including the possibility of setting up what Florida now has, which is a community property trust law. So if Marcia and I own our assets jointly, I die, half of the assets get a step up to fair market value for income tax purposes. The other half don't if they're joint. But anyone from anywhere in the world can set up a Florida community property trust. You just need a properly drafted trust and a Florida trustee. And then on the death of the first dying spouse, the statute is designed to provide a full step up in basis for all assets in that trust. Now, we have separate videos on this. We have separate articles on this. The Florida Community Property Trust may or may not work. There's something else that we developed called the Joint Exempt Step-Up Trust that we believe will work. at least as well as a community property trust and has other advantages. I won't go so deep into that other than to remind people that there's a lot of things to think about in an estate plan. Certainly a lot more than I can cover in the next 16 minutes, which for many of you is 1/2 of a billable hour. So now we talk about the great and wonderful, sorry to be verbose, revocable trust. And many of us have gone to luncheons and learned that if we would only put our assets in a revocable trust, they will avoid the demonic probate process and guardianship and make it very easy for our descendants to get hold of our assets and do what needs to be done when we die. It's absolutely true, but probate isn't always that bad. It is a lot of paperwork. Typically, probate is $3,000 to $4,000 worth of paperwork and quite a few hours of getting paperwork together so that the judge can approve, one, who is the right personal representative under the will? Number two, is this person trustworthy? Number three, is there insurance? So if they steal, it's covered by what's called a bond. Number four, did they give the right notice to all the beneficiaries? Number five, did they pay the expenses? Did they pay the taxes? Number six, did everybody get what they were supposed to get? And number seven, did you close the estate? Well, you could see how that could be $3,000 to $4,000 worth of paperwork. But a lot of the things I just mentioned are things that have to be done in a trust. And the big expense in probate is either number one, law firms, trustees, and personal representatives are allowed to charge a percentage under the statute, but we usually don't. So find someone who's not going to charge you a percentage if that's the concern. Or number two, you can only imagine how much time it takes to organize somebody's affairs when they've never been organized their whole life. Oh, grandpa died. He had 26 companies. He never had an operating agreement. This one, he was having a dispute with his partner. This one, he didn't tell the IRS the right stuff. This one, the company has this property, but the other property, it's supposed to have that property, not this property. Grandpa messed stuff up for 50 to 70 years, and we have to clean it up. So don't be that grandpa. Don't be a bad grandpa. Be a good grandpa. Get your stuff organized. So anyway, off on a tangent there, as Richard Green used to say, or probably still says. Now, we often use an irrevocable trust. And a very common type of irrevocable trust is an ILIT, which stands for Irrevocable Life Insurance Trust, and a SLAT, which stands for Spousal Limited Access Trust. I put $1 million of investments into a trust for Marcia's health, education, maintenance, and support. She's the trustee. She gets what she needs. On her death, she devises it to our children as she sees fit. It's not subject to my creditor claims because I'm not a beneficiary. It's not subject to her creditor claims because she didn't fund it. It's out of her estate for estate tax purposes. And under the new Florida statute, which took effect this last summer, if the spouse dies, then the donor can become a beneficiary and it will still not be subject to creditor claims. So there's a lot of confusion over that. There's a lot of complexity. But the bottom line is, if you have a client who has a spouse that's not in good health or has a short life expectancy, your client could put $10 million into that trust. It has to be for the lifetime benefit of that other spouse. But on that spouse's death, then it can benefit your client and not be subject to creditor claims. So it might be something worth considering. like I said, there's a lot of issues, a lot of questions, but in any event, that's what it is. All right. Josh, did we handle all the polling questions? One more. Okay. Where is that? What page is it on? What is that? 170. What I used to weigh. Okay. Would you be interested in sponsoring minority students to participate in an estate planning council? And the way this works is the law school will award the student a grant. The student will be an honorary member of your estate planning council. The student will attend estate planning council meetings, and the student, to get their pro bono hours required by the law school, as part of this, will put together materials and a presentation to bring to communities or organizations or people in need to teach them about the importance of estate planning and naming guardians and signing wills as to where their assets will go, especially if they have young children. So if you or your estate planning counselor would be interested in participating in this type of program, as profiled in Wealth Management magazine and as now being worked on by the Diversity Committee of the National Association of Estate Planning Councils, then the answer is yes. If you're not sure, B, please send more information. And a polite way of saying no is C, what was the question? James, why only minority students? Well, that's what I'm working on. I'm working on this for minority students, but it can be any kind of student you like. And thank you very much for your thoughts on that. Daniel, yes, the book is old. It hasn't been updated. I'm hoping this summer that the law clerks will be able to update the book, in part by watching this webinar if they don't fall asleep. Okay. Here on page 156 is a classic Florida estate plan for a moderately or greatly wealthy client, married couple. You have the two spouses, each have a revocable trust. You have a lot of assets as tenants by the entireties. You have a slat on the far right. You have a trust only for the children. Second to the right, you keep the life insurance and annuities outside of the trusts. And then you show page 157, a second tier. You can use LLCs owned partly in tenants by the entireties, partly by the trust for the children, to reduce estate tax exposure and to increase creditor protection. Because if both spouses get sued because their dog barks at the next door neighbor and the next door neighbor falls down and gets a concussion and sues for millions of dollars, then she cannot get into the LLC. She can only get what's called a charging order, and she will hopefully settle for the $5 million umbrella that I hope your clients have. And there is a video on YouTube called What Mary Poppins Didn't Know About Umbrellas, and it's not about that kind of umbrella. It's about an insurance umbrella, which should be discussed with clients. Okay, then there's stuff on the gist here. Step 6, select good trustees, guardians, personal representatives, and other fiduciaries. And I have to say, a lot of times Uncle Joe just seems like such a nice guy. He goes to all the family events, he combs his hair, he brushes his teeth, and he's a terrible trustee. The client dies. He's got a little drinking problem no one really knew about. He borrows money from the trust. He can't quite get anything done. His next door neighbor is a rip-off artist advisor. It is safer to say that Uncle Joe will serve as co-trustee with his choice of any licensed trust company or the family lawyer or the family CPA, so that Uncle Joe has some help. Guardians for your children do not have to be family members. They can be people you know who did a darn good job raising their children. So chapter 6 is to think about who you are appointing. You know, I have clients who want to appoint their 18-year-old children to make their healthcare decisions. Do you know how intimidating it can be to walk into intensive care and to be getting advice from medical professionals and be afraid to ask for a second opinion? I want somebody who's going to advocate for my health in a hospital or a healthcare facility, not someone who's going to be compliant and also have nightmares the rest of their lives because of the experience that you can have there. So on the healthcare power of attorney, I like to appoint 3 or 4 people. They can all serve together. Whoever can get there first to help me, whoever happens to be there at 3 in the morning to talk to the nurse and look in the medical file. So that is step number 6. Oop, I just saw a typo somewhere. We'll find it later. Then, do you have a child care power of attorney that addresses the care of children under the age of 18? Do you have a healthcare power of attorney? Like I said, I like to appoint plenty of different people, and there are some decision charts that we have here. Number 8, special considerations, which include the complexity of planning for people who have children by prior marriages. That's about the most complicated estate planning. Well, if I die, how do I take care of my spouse, but also make sure my spouse takes care of my children, and vice versa? And you mix that in with estate tax planning, and it can be very, very challenging. And sometimes it's best just to buy term insurance and say, if I die before this term policy ends, give that money to my kids and let my spouse do what my spouse is going to do with hers. And then how do you protect premarital assets when you're married and you don't have a premarital agreement? Can you go ahead and get a post-marital agreement? How do you handle Florida's completely antiquated homestead laws? If I die with 1 minor child and the homestead is in my name alone, then it automatically vests at the moment of my death in equal shares to my children, no matter what my will says. Or if I'm married, my spouse only gets her choice of a life estate or 50% ownership. So you have to be very careful when you are doing this in Florida because of how strange our laws are on the homestead. People forget that the surviving spouse gets at least 30% of the elective share estate. And then there is Medicaid planning. Medicaid planning, very difficult, very complicated, sometimes very worthwhile. People don't realize that if you're married, there's wonderful loopholes that would allow you to put almost all your assets in your spouse's name. Your spouse then signs a refusal to share, and then you go on Medicaid. Alternatively, you're single, you can keep a home worth about $600,000. You can keep your car worth an unlimited amount. You can pay your children for a lifetime of care, and then what's left may need to be spent down to get on Medicaid. There's no substitute to seeing a lawyer who specializes in Medicaid eligibility. And a lot of lawyers call themselves elder lawyers. Maybe that's because they're old themselves or their clients are old. You want to get to one of the really good ones to make sure that you get the right advice in that area. And then there's planning for addicts and planning for children with special needs. So I haven't even hardly mentioned estate tax planning, which I can do at the end of the program. I really appreciate the opportunity to have gone through these 8 steps. I hope that if you are not an estate planner, you realize that there's a lot of things that need to be thought about and attended to. There are other pages in the materials that may be of interest. Let me just answer questions now for a couple of minutes. Then we'll be done, and I will be explaining the Estate View estate tax software again as a practice run. Okay, Linda or anyone, if you can't get the handouts, we will, you know what, Josh, let's just email everybody the handouts. Everybody can just get one more email in their life today, and that would be the handouts. Okay, Sinitra, that's a beautiful name. Husband and wife without children, one of them passes away and all assets are paid on death. Will the assets go to the other spouse without going through the probate court? Yes. In other words, if I have a joint account with Marcia, or I have an account in my name that says pay to Marcia on my death, then it goes directly and there is no probate. All right. Wayne, parent has a life estate, parent dies in 2010, asset is sold in 2020. Is the stepped up basis applies when she dies or when the property's sold? Wayne, it's when she dies. So let's say Marcia and I have a house, we paid $1 million for it, it's worth $10 million. We own it jointly, I die. My half of the house now has a $5 million basis. Marcia's half of the house now has a $500,000 basis. She sells the house and she pays capital gains tax on $4 million, on $4,500,000 plus 100% of any appreciation that occurred after my death. On the other hand, if we had that house in a community property trust or in a JEST joint exempt step-up trust, then it would have gotten a full step up to $10 million on my death. So it would have been worth the complexity. Okay. Let me see if there were any other answers that I know the answer to. Okay. James, does the recent IRS ruling regarding trust assets not getting the step up affect your planning scenarios? Not in the examples I gave. The IRS issued Revenue Ruling 2013-2 recently, which says that if I set up an irrevocable trust, not for me, but for other people, and the trust is considered to be owned by me for income tax purposes, then on my death, according to the IRS, there's no new income tax basis because I didn't own the trust assets. Now, my argument is that if the income tax law says I own it under Code Section 671, why don't I own it under the stepped up basis law provision at Section 1014? So if you want a copy of our article on 2013-2, please let me know and we'll be glad to share it and to accept your input on that. Okay. Again, I thank you for being such an attentive audience, and the show is over. It's now intermission. Intermission's over. Now it's time for me to show off the Estate View software program and to have a walkthrough with you. And this will enable our beta users. And if you're interested in being a beta user, just, I'm not talking about the fish, I'm talking about the actual software. If you're interested in being a beta user, just let us know. So the Estate View software today has 4 modules. The first module will show a married couple what their estate tax exposure is and how to reduce their estate tax exposure using the various conventional and most popular techniques for this. It will also generate an explanation letter explaining the techniques specifically as the numbers apply to that client. And that is the mode that we are in now. The second mode, the installment sale calculator, allows the planner to walk through a installment sale arrangement for a single individual and to generate the spreadsheet that you see here as an Excel spreadsheet that shows how the installment sale can reduce federal estate tax. The third calculator is for the Qualified Personal Residence Trust, which I will show you in conjunction with a separate spreadsheet that I'm going to share with everybody for that. And the fourth calculator is the grantor retained annuity trust. Now, Kevin, my programmer and present co-creator, was up all night working on the self-canceling installment note module, which is coming along really well. So I hope to be able to show it sometime next week. Going to the first module, I want to take you slowly through the information intake. So the information intake is, number one, you can type in your law firm name as you wish, and then you can type in your name, and then you can type in your client's name. Very easy to type it in. And then if you want to give your client's date of birth, you can, or if you just want to provide the age of the client, you can. And we will say that Bob is 70 years old, and we'll make Bob a male so we don't confuse anybody here. And here we find that Bob's actuarial life expectancy is to 2035, but we could show him living to a little longer, say 2037. We also know that if he's a tobacco user, we can click there, and then his life expectancy goes down by 2 years if he is a smoker of tobacco. Now, we're going to say that he's used $1,750,000 of his $12,920,000 estate tax exemption. We're going to say that until he's age 75, he's going to work, and as a married couple, Bob and his wife are going to save $500,000 net of taxes while their investments continue to grow. And at age 75, he's going to retire, and he's going to get a pension, but they're going to spend $200,000 more than comes in with pension and Social Security after taxes once he is 75. Now, his lovely spouse, Mary, is, let's say, 65, and her life expectancy is till 2042. Most people live past normal life expectancy because they're non-smokers and because wealthy people get more health care than the average. We'll give her until 2047. That's 24 years. And we'll keep her numbers consistent with Bob's. So she'll add nothing to savings herself, but once Bob has passed away, she'll be spending $200,000 a year. Okay, then here the question is, when Bob dies first, if they don't use his whole exemption, will she have the ability to use his portability allowance? So he dies with a $13 million exemption. He only uses $5 million. Will she have the opportunity to use that $8 million? The answer is yes, so I don't check that box. And then will the estate tax exemption drop to 50% of its present level in 2026? And we'll say no, we'll just leave that unchecked. Then they have a home. It's worth $1,750,000. It's growing at 3.53%. Let's move that up to 3.78% a year. And they have business and investment interests worth $18,750,000, growing at 8.25% a year. They pay 0.5% in investment costs, and they pay 2% of the value of that portfolio and those assets in income taxes every year. And on the first death, we're going to say that the credit shelter trust that Bob can leave for Mary's health education maintenance would be no more than $11,780,000 a year. Now, let me just show you what that does on the right-hand side. So on the right-hand side, I can first show you with that information. Oh, by the way, I'm sorry. Let me talk about their life insurance for a second. They have life insurance. Bob has a $1 million policy that's costing $5,000 a year. And after 8 years, it's going to start costing $20,000 a year. And after 11 years, it's going to pay a death benefit of $1.3 million. It is not in a life insurance trust, but part of the planning will be to put it in a life insurance trust. Same type of situation for Mary. And then there's also a second to die life insurance policy. Same situation in general. So their first question is, if we don't do any planning at all and we die this year, what happens? So I click here, top right, current estate, no planning, and we see no estate tax. You see the house is worth $1,750,000, investments $18,750,000. You've got the life insurance, and then you have 1 year of growth. And on the second death, you've got a huge exemption because of the portability allowance. And there's no estate tax on $23 million worth of assets. Then we go to no planning with growth using the portability allowance. What happens in 24 years? And by the way, you see the 24 years there? One thing I like here is if we just kill her off earlier, then that goes to 21 years. It tracks it. So I click there, and now there's a little bit of an estate tax issue. On Bob's death in year 14, the house is worth $2.9 million, investments are worth $39 million. And on the second death, Mary's assets cause an estate tax of $13,926,000. A not so good situation. Now, the third alternative is I go to fund a credit shelter trust on the first death. I click there, and I have now a situation where, oops, let me just get this to the right size. I'll size it right. The bypass trust gets $11,780,000 on the first death, but the portability allowance comes down. And on the second death, the bypass trust is worth $17,399,000, which avoids estate tax. So the estate tax now is lower. So those are the first three modules. Let me just make mention at this point that if Mary remarries and loses her portability allowance because her next spouse dies before her with no such allowance, I click here and I see that that estate tax is $13,742,000. And if the estate tax exemption drops in 2026 to half, I click here and the estate tax would be $22 million. That makes a big difference because that reduces what can go into the credit shelter trust. See, if I don't click that, this credit shelter trust should get more. Okay. So now I want to show you the gifting and life insurance. So they have already put $500,000 into an irrevocable, well, let's say they haven't. They've put nothing in an irrevocable into an irrevocable trust for their children. they have 2 children for the first 11 years, but they're expecting grandchildren. So we'll say after 11 years, they have 4 beneficiaries that they can gift. And this is for using the $17,000 per person per year gift tax exclusion. And we're going to say 15% of that is going to be cash going to the kids. 85% of it is going to be going to a trust for the kids. And they may give cash, or they might give discounted LLC interests using a 30% discount, because they would be giving partial ownership in an LLC that would be valued at 30%, at 70% of what it would otherwise be. So what does that do for them? I come down here to annual gifting. I click on annual gifting, and now the gift trust, so the estate tax goes from 22.5 million down to 20 million. And you see that the gift trust by the first death has 1.9 million. By the second death, it has 4,170,000. Now, if they do the discounted gifting, then I would click here. Now the estate tax is down to 19,850. The gifting trust is at 5,689,000. Now let's say they just want to change something. Let's say they decide they'd like to give the children no cash and 100% LLC interests. Well, you see the numbers change as a result of that. All right, then we can see what happens if we put the life insurance into life insurance trusts, and you've got a better result. You've brought the estate tax down from 19 million to 16 million using the life insurance trusts. And now we go to the installment sale application. Now, I'll give you some numbers here that we can use. Let's just say that they put $13,572,633 worth of investments into an LLC, and they believe that a 99% non-voting member interest in that LLC should be discounted based upon a 28% discount rate. So the 99% ownership interest in the LLC is worth $9,093,000. And we will assume that the applicable federal rate for a long-term note is 3.88%. And we are going to have Bob set up a trust. He's going to put $909,000 into the trust as a seed capital gift. He's going to sell the trust, the 99% non-voting member interest in this LLC, for a $9,093,000 15-year note at 3.88% interest. He's going to pay all the income tax attributable to the income of that trust. And there's going to be no guarantee fee. I'll skip over the guarantee fee aspects of this, but if you are more sophisticated, you can make this a self-canceling installment note with a higher interest rate, and you can provide for the payment of a guarantee fee if the client doesn't want to have a 10% seed capital gift, if you believe that that's important. So now I click on installment sale with a 15-year note, and my estate tax has gone down from 16,000,006 to 7,427,000. Now, then the client says, well, how much will this 60 million that my children be getting, how much will that be worth in that many years? Well, if inflation is going to be 4.5%, I can adjust for inflation. Oh, by the way, I am showing the estate tax rate at 50% because I'm assuming that there's a federal rate of 40% and a state rate of 10%. If I want to adjust down to a 40% estate tax rate, I can do that, and the estate tax will be less. Let me go down to 40. I'm assuming that the chained inflation, which is the CPI index used to increase the estate tax exemption and annual gifting allowance, is at 2.71%. That's pretty much what it's averaged in the last 15 years. If I want to move it up a little bit, then I'm moving the estate tax up, down a little bit. If inflation is going to be 4.5%, I click here and it tells me, look at that. What my children were going to get 63 million, but in tomorrow's dollars, it's only going to be worth 25 million. So I really do need to save as much estate tax as I can. All right, so that's the general story. There are 3 views. The first view is the timeline view. I mean, the logistics view, which I've been showing you. And I can expand it a little bit by going like that. And then, let me just move it down just a little bit. So there it is. But I also can do a timeline view. Now this shows me the purple is the installment sale trust. You see it has a large value from the beginning because of the discount, and then it goes up in value. Then I've got the different life insurance trusts, and you can see when the life insurance matures on the second death. I've got the bypass trust, which happens on the first death. I've got the residence, and I've got the business investments, and the red is the estate tax. What's kind of fun here is you can move the second death back and forth and see where we're changing the date of the second death would change the estate tax. And you can go here and say, well, I guess I should have done a bigger installment sale. How much can I go ahead and move my initial seed capital gift up, move my installment sale up? That's going to move the estate taxes down. I can also look at this from the point of view of annual amounts for each separate item. So if I want to know what happened under the under the gifting trust, this shows me the actual annual contributions and how much was in the trust each year. And then I can get an abbreviated time slip here. I'm going to, by the way, this red tells me that I'm looking at inflation adjusted to remind me to get rid of that because it can be very confusing. Okay, so now I have this where I want it, and I want to write the client a letter. I click on Generate Client Letter. And then what do I want to show the client? Well, I'd like to show the client no planning. I'd like to show the bypass. I'd like to show annual gifting. I don't think they're interested in discounted gifting, but I'll show it. I'll show it all. And then would I like to show the timelines? That was where you saw the red go across. Sure, I'll show that. Would I like to show the details? No. Okay, I click Generate Client Letter, and now the program is generating a letter. Now, while we're waiting for the letter, let me mention that this is now working on iPads, Apple computers, and even cell phones. You can put all this information in on a cell phone and see it on a cell phone. So it's coming along very nicely. So the letter, as you see, is almost completed here. I guess all those little squirrels writing the letter, they're proofreading it. Now they're putting in all the ink. Okay, so there's my letter. I click on it. It's a Word document. I can enable editing. And I was also able to type in anything I'd like to type into the letter. Thanks for letting us do this. Then it explains the estate tax system. It gives me all my inputs. And then it shows what happens with each scenario, how much it saves, and what the scenario means. So then I can save the letter, use it for later. It will also allow me to save by screenshot or save the entire arrangement. So I just did a screenshot, so that screenshot is now saved on my computer and can be viewed later. And then I can go ahead and hide the variables if I want to have a bigger presentation on the slide, and I can even hide the scenarios if I want to have a bigger presentation there. So that is the primary module. I'm going to take you now to the Cupert calculator. Now, a qualified personal residence trust is a trust that you can gift a home to. You can gift a primary home or a vacation home. Everybody can gift up to 2 homes. And when you put the home into the qualified personal residence trust, you set a term. You choose what the term is. It could be, say, 8 years. You put the home in the trust. You have the right to use it for free for 8 years. Because of that, the value of the gift to the home is less than the value of the home itself, because they've got to wait 8 years before it's technically inherited. So you use the IRS discount rates, known as the Section 7520 rate, and you use the IRS actuarial tables in order to calculate what the value of the gift is, because if you die during the 8-year term, it's still in the estate. So I'm going to use the basic mode here. The transfer date is April 13, 2023. The 7520 rate right now is 4.4%. I'm going to say that the grantor is age 68, and he's interested in a 10-year a 10-year Cupert. The home is worth $2 million. Gift tax rate 40%, estate tax rate 40%. And we're going to use the best mortality table possible, but you would have your choice of the mortality tables. All right, so with these settings, the value of the gift is $944,000. So I put a $2 million home in this trust. I file a gift tax return using only $944,000 of the client's exemption. That's 47.24% of $2 million. And there's a 72.67% chance that this 68-year-old will survive the term. Well, I like to have at least an 80% chance, so I can reduce the term to 8 years and have a 79.55% chance, $1,127,000 gift. And then I'm going to take you now to advanced. And with advanced, I can tell the computer what year to show death, maybe age 86. I can show you the growth rate of the home. Let's say it's going to grow at 5% a year. The client owns 100%, and the rent that the client will have to pay after the 8th year will be based on 8% of the home. The client will stay in the home for her entire lifetime. So what happens here on the numbers? Each year, the home is going up in value, and there's no rent until year 8. Beginning in year 8, the rent is paid to the trust. That reduces the client's estate, and the assets passing outside of the client's estate, based on a $1,127,000 gift, start at $3,339,000 at the end of year 8. And by age 86, we've removed $8.4 million from the client's estate. Now we're going to add a column for estate tax savings, which in this case will be 40% of that, $3.2 million. So that would be one advanced scenario. But now what our law firm normally does for a married couple is we do two cuperts. So we do one for each spouse. One spouse forms a cupert that can benefit the surviving spouse for health, education, and maintenance. The second spouse does a cupert that benefits only the second spouse for the term of years and is then held for the descendants. So to do a second cupert, I click on duplicate. And now I have my input for the second cupert. Now, this second spouse may be only 64 years old. And if I'm using an 80% rule of thumb, I can do a 10-year cupert here. The value of the home is still $2 million. But what I can do here is say, I'm only giving 50% of the home. So as a result of that, I can use a discount. So 50% of a $2 million home is $1 million. But if I take a 15% discount, take into account that no one would ever want to buy half of a home, then because of that 15% discount, you see the amount of the gift goes down from $520,000 to $442,000, still paying 8% rent on that half of the home. So the numbers for Cupert 2, when I click there, are pretty darn nice. Certainly better than they were for Cupert 1. And then I can go back to Cupert 1 and make that simple change to have the first spouse at 50% ownership interest, 15% rate. So then I have these combined savings. So the other thing that we are developing, and one of the parts I really like, is this handy dandy chart, which shows you on the left the amount of value moving outside of the estate, and on the right, the probability of it working. You have a 79.5% chance of moving this much value out of the estate. So when you move your numbers, when you move the term, you see the circles changing. The higher I go, the more I save, but the lower chance of actually living that long. Okay, now I have a spreadsheet for the Cupert that I just want to share. And eventually what we'll have is that this module will push everything into this spreadsheet. So then under the spreadsheet, you see the same numbers for both spouses together. You see the estate tax savings for both spouses together. And then you have an income tax analysis because they're going to possibly pay more income tax on the second death or whenever the home is sold. But the estate tax will almost always outweigh the income tax, and the estate tax is due as soon as they die. The income tax isn't due until they sell the home. In addition, I have arrows on the spreadsheet, so you can change the key numbers on the spreadsheet once it goes to spreadsheet mode by arrowing up and down. So that is the Cupert module as it stands today. The last thing I want to show you right now is where we are on the Grantor Retained Annuity Trust module. Now, a Grantor Retained Annuity Trust is a trust that enables me to put assets in the trust and receive payments back, and what's left in the trust after I get my payments passes estate tax free. So to give you a basic example, you take a grantor age 60 and he wants to do a 2-year GRAT, and he believes the assets will grow at 7% a year. He wants the remainder interest in the GRAT to be worth about $2,500, and he's going to put $1 million into the GRAT. So he puts $1 million into the GRAT. He's going to get back 2 annual payments of $531,914 a year for 2 years. He's going to report a gift of $2,479 on formation of the GRAT. And if the assets in the GRAT grow at 7%, then at the end of the second year, the GRAT has $43,836 that go out estate tax free. So he's taken $40,000 out of the estate tax system. Now, if he wants, he can have, instead of annual payments under the GRAT, you're allowed to have the payments increase by 20% a year. So I can click here to increasing 20% a year. So now you see the first payment is going to be $484,496. The second payment, $581,396. And what's left at the end is $45,000 now. So that saves about $2,000 or increases the assets by about $2,000. Now, to make it more exciting, let's say you have an S corporation worth $10 million, and it's growing at 8%, and in order to, and it's, let's say that it's throwing off income of $500,000 a year. So you have a S corporation, throws off income of $500,000 a year. Otherwise, it grows. So the client puts it in a 10-year GRAT. So the 10-year GRAT is going to, well, let's go to level. And this is very interesting. So let's say the GRAT, let's say that this S corp throws off income of $1,257,000 a year, and it's worth $10 million. He puts it in the GRAT. The GRAT is going to basically just pay him the income back that he would have been getting. He uses only $2,540 of his estate tax credit. He receives all these payments, and in year 10, the company is still owned 100% by the GRAT. And if we go to advanced and we show that the asset growth rate is at 8%, even without showing the income coming out, the GRAT has a significant value at the end of the 9th year. But let's say that while we know the company is worth $10 million, we only give non-voting member interests. So we decide we're going to use a 25% discount rate. So I go here to 25% discount rate, and it turns out that I only have here a $7 million GRAT, but there's $10 million worth of assets that I am starting with. So the payment amount can be reduced to take that into account, and the amount remaining in the GRAT will be that much less. So then if I want to export my spreadsheet to Excel, I can export the spreadsheet to Excel. There it is. Somewhere it is on my computer. One other thing, oh, there it is. Open. All right. Then one other thing I want to show you, going back to the Cupert, is that you can get an explanation of each Cupert by clicking Generate Explanation. If you want for one or both, submit, and then there is your Cupert 1 explanation, your Cupert 2 explanation. You can order a simple explanation for one or for both. When I hit Basic and I hit Explanation, then I get the simpler explanations. Okay, so the final item is the installment sale calculator. You put in the client's net worth, their annual savings or spending amount, separate and apart from growth, asset growth, income tax rate as a percentage of the assets, lifetime exclusion already used, what's your seed capital gift, what are you putting into the LLC, what is your discount rate, what is your net value, that gives you your note amount, what is your interest rate, what is your estate tax rate, what is your CPI rate, are you using a conventional note or a self-canceling note, how many years until it balloons, at what year would you toggle off grantor trust status where the grantor would start paying the tax on it himself, and how many years do you want to show. Click on full fit, and it's pretty small, but it's there. And then click on Save Results to Excel, and it exports into the Excel spreadsheet, which you can then show to the client and add as many clients as you like. We have not yet written the explanation letter for this. There's one other thing I forgot to show you. Back to the main module, and that is a single individual. You click deceased or non-applicable to spouse 2, and then you tell it if the client is a widower or a widow, you can tell whether there was a portability allowance and how much it was, and whether there's a credit shelter trust or any other trusts and how much they are. And then otherwise this runs but for a single person instead of a married person. Okay, well, that was a 41-minute explanation of Estate View. I want to thank all of you who held on through the end, and much appreciate any questions, comments, or suggestions you may have. If you would like to be a beta tester, you are welcome to do so. Thank you very much to David Archer, Jerry Hash, and Kevin Gray for all the work and all of the ideas that they have had to make this what I hope will be an extremely useful and time-saving device for estate planners. Have a great rest of your weekend, and thank you so much for attending this webinar and for being a client of ours, or a member of the Florida Bar, or a subscriber to CPA Academy. Thank you.